A group of North Carolinians are suing the Department of Homeland Security, accusing agents of making arrests without probable cause. The filing shows Customs and Border Patrol agents arrested 4 U.S. citizens here in the Charlotte area during Operation Charlotte's Web from last November. A man from El Salvador, who's a legal resident, was also taken into custody. The lawsuit claims agents arrested the men without taking the steps to verify their citizenship first, which violates federal law.
We did hear from a Department of Homeland Security spokesperson about the claims. They tell us in part that the ACLU who filed the lawsuit only cares about illegal immigrants and not Americans. The statement goes on to say the allegations that immigration agents racially profile are disgusting.
Bringing in our chief legal analyst, Khalif Roots, for our final topic today. Khalif, here we go. We know that federal law allows these agents to make some warrantless arrests with limitations, right? What are the plaintiffs, what are they saying happened specifically in Charlotte?
Well, they're saying a couple of things. I mean, there are 2 baselines for their argument: warrantless arrest without individualized removal determinations and warrantless arrest without individualized escape risk. And so the first one says that they arrested these folks without a warrant and without reason to believe that the plaintiffs were in the United States in violation of any immigration law or regulation. So that's the first one. The second one is they made this without reason to believe that plaintiffs were in some subclass of being able to escape and likely to escape before a warrant could be obtained. Those are the only ways that you can arrest someone without a warrant or detain someone without a warrant in these scenarios. And so what they're alleging here, and back to that statement, what DHS responded, while you may make the statement and make the claim about only caring for American citizens, in their complaint, it's not about American citizens versus non-citizens. It's have you complied with what the requirements are, specifically constitutionally, the 4th Amendment. If you're going to detain, arrest, or remove someone, you got to make sure that you're going and doing the things that are required through a number of U.S. codes, but specifically the Constitution.
So what's the next step for this lawsuit then? Who looks at this next?
Obviously a court, and I mean, this is my favorite part. So within the complaint, you'll see the counts, and you'll have a number of counts, and they're called claims for relief. The 2 that I mentioned to Jason's questions were count 1 and count 2. But away at the end of every complaint is the best part, and that's that prayer for relief. You're praying and you're asking the court, because most of our court system was founded in English, Old English terms, and so they used a lot of religious terms. We're praying that the court will now do what I'm asking them to do. And they list a number of things. First, certify the class. This is a class of individuals, 5, but there are likely more individuals out there. So we don't want just relief for these 5. We want the entire class to be certified. Once you certify the class, allow the attorneys, these 4 attorneys that brought this claim, to be listed as the class's attorney. Then we want you to make a declaratory judgment. Declare what the state, not the state, but the United States government was doing was unlawful and unconstitutional. And they asked for those 2 declarations. And then finally, they're asking for vacate. Set aside those policies. If you've determined that they are unlawful and unconstitutional, vacate, remove, and terminate those policies. And then finally, our favorite topic here, injunction. You already knew it. Andy was ready before I said it. that if you find that there is now some irreparable harm, likelihood of success, balancing of the equities and public policy, Your Honor, we want you to give us an injunction to stop them from doing this. So they list a number of prayers, and they're praying that the court will, enact some of these things.
If the prayers are answered, if the injunction is granted, what does the trickle-down effect immediately? What does that look like statewide operation-wise?
Well, I would say trickle-down in immediate is appeal. I mean, obviously, the Trump administration has appealed any U.S. District Court's ruling that has went against them to either the Court of Appeals or an emergency basis to the Supreme Court. I think that would be the obvious next step and logical next step, because a number of these things could be challenged on that level. But I think once it gets to some type of finality, I mean, judges' orders have to be followed. So we have to start there. If a United States District Court judge does any of these things, the next step is that the government has to stop doing whatever the judge says. Now, these judges have been extremely intentional in giving the government time to appeal, because typically the judge's order goes in that moment, it's the law. Now, the judge is saying, I'll give you 15 days. I'll give you 20 days because I don't want it to be enacted and then now you're violating something that I told you not to do. I'll give you this grace period because I know you're going to appeal. And we just talked about it earlier this morning. The judge gave him 14 days to go ahead and appeal. That's been typical for the last year and a half, where any judge that has done something against the Trump administration and ruled against them, they've given them this opportunity to appeal because they know that appeal's coming.
Well, as you mentioned, this is a class, so this likely will not be the first lawsuit of its kind that we will see, not just here in North Carolina, but probably all over the country. So, Kali, thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.